all of you. I'm Deborah Rohde, the director of the Center on the Legal Profession, and so delighted to welcome you all here today. Certainly from a legal ethics standpoint, this is kind of the worst of times and the best of times. Worst maybe for the country, but best for people who think about legal ethics, because for once we kind of have the nation's attention. And here we are with one of the nation's leading experts on the subject. I want to start by just saying a word about the focus and the format of this panel, introduce our panelists, say a word about the topics we'll cover. Each of us will talk for a few minutes, and then we'll throw it open to questions from all of you. I want to start by emphasizing that this event was planned in advance of Mr. Painter's announcement that he's running for office in Minnesota, and without any knowledge of that. And this is a nonpartisan discussion of current legal ethics issues. It's not an endorsement by Stanford of his political platform, and we're talking about the lawyers in the Trump administration. I stress this point because some of you may have seen an op-ed in the Stanford Daily today, which criticized us on a variety of grounds, including the invitation to Professor Painter. They thought the title was bland and sanctimonious, that David and I were strident partisans, never a good thing in a woman. David, you're probably okay. And that we had invited an avowed candidate for office. Well, you know, if you said that universities could never have anyone who was serving in Congress or thinking about serving in Congress, I think we would be the worst for that view of the ethics rules. That's not how we read them. And of course, I think that for any ethics professors to be talking about legal ethics at this historical moment and ignore what's going on in the world around us would in itself be an abdication of ethical responsibility. So having said that, we've decided to, since time is short and the issues are endless, to focus on four main questions and then open it up to questions from all of you on any topics. First of all, what does any lawyer in a government administration think about when to serve and when to resign, and how to think about that, and especially in a highly partisan moment? And secondly, we'll drill down on a couple of clusters of lawyers in this administration, the lawyers in the Department of Justice involving the Russia investigation, and the lawyers in the Solicitor General's office in their request for sanctions against ACLU lawyers in connection with the reproductive rights question. And then we'll also talk, because how can we not, about Michael Cohen and Stormy Daniels and all that that raised. A word about our panelists. Richard Painter is a summa cum laude graduate of Harvard and got his law degree from Yale University. He clerked for Judge Noonan on the Ninth Circuit, practiced at Sullivan and Cromwell in New York City, and Finn Dixon Hurling in Stamford, Connecticut. He's an expert both on corporate law and, for present purposes, most obviously on legal ethics and especially on government ethics. From February 2005 to 2007, during the Bush administration, he was associate counsel to the president in the White House counsel's office, serving as the chief ethics lawyer for the president, White House employees, and senior nominees for Senate-confirmed positions in the executive branch. He's a prolific author, a leading commentator on legal ethics issues, and we are so grateful that he's taken the time to be with us today. David Slansky, as I know all of you know, is a professor here, co-director of the Criminal Justice Center, a leader in the field of prosecutorial ethics. Before joining the faculty at Stanford, he taught at Berkeley, UCLA, practiced labor law in Washington, served as an assistant U.S. attorney in Los Angeles, and has a lot of direct experience and insight into the role of government lawyers in a prosecutorial capacity. So I'm going to throw it open to you. Richard, start us off.
Well, I will begin our conversation by focusing on the Justice Department and what's going on with respect to the investigation by Robert Mueller. I haven't seen a situation really at all similar to this since I was 12 years old. I remember my dad coming home and saying that a man named Archie Cox had been fired. I didn't know who Archie Cox was. I said, what was he doing? Investigating the president. Who fired him? The president. Well, actually, that isn't technically how it was done, but he was trying to simplify it for me there. Even then, at age 12 years old, I knew something was wrong, that if the president is firing the man who's investigating the president. Now, of course, in order to fire Archie Cox, and I believe it would probably be the same with respect to Robert Mueller, there's some debate about this, the president needs to convince the Attorney General to do the firing or the Deputy AG, and if they won't, replace them. And Richard Nixon had to go through the Attorney General, Mr. Elliot Richardson. He refused. Out he goes. Then along came Mr. Ruckelshaus. He refused. Out he goes. And Robert Bork, well, he's actually, I think, encouraged to do it by some of the others, and maybe he was thinking about future Supreme Court appointments or whatever, and he did the dirty deed. But the role of the independent counsel is a fascinating one. We tried to address this with an independent counsel statute, but that didn't work so well during the Clinton years for reasons that I won't get into. But we are now in a situation really quite similar to what we had in the Nixon years. How do we get here? Conflicts of interest. The Attorney General, Mr. Sessions, rightfully recognized that he had a serious conflict of interest under both the ethics rules for lawyers, Rule 1.7, which is really quite broad in its scope. It doesn't just cover former client or current client conflicts. It also covers conflicts with personal interests or any other organization you might have a loyalty to or past allegiances. And since Mr. Sessions had been very much involved in the Trump campaign, it really wouldn't comply with the ethics rule, with what Rule 1.7 for lawyers, for him to be representing the United States government in connection with its investigation of anything that happened in the Trump campaign. So I think recusal was called for from the beginning for Attorney General Sessions. He also, of course, once you enter the government, you're bound not by just by the ethics rules for lawyers, which you cannot leave at the door. You have to comply with the ethics rules for lawyers, but you have an additional set of rules that apply to all government officials. And there's an impartiality rule for all United States government officials in the Code of Federal Regulation 5, Code of Federal Regulation 2635, 502. It's just called the impartiality rule. If it's a particular party matter and you have a relationship with one of the parties, they define a covered relationship in such a way that he clearly did. Relationship with the Trump campaign that was being investigated, you must recuse. So you put those two rules together, and really from day one, Attorney General Sessions needed to recuse. Now he didn't do so right away. He sort of did sort of recused, sort of did not. But then he got caught in a very awkward conversation with Senator Franken. Well, it was actually sworn testimony. Senator Franken did not think it was particularly accurate, and a number of people, including myself, made some noise about the accuracy of his testimony. And so at that point, Attorney General Sessions decided there was some pressure on him to resign at the time, but instead of resigning, that what he would do is recuse from Russia. And he really didn't have much choice in that regard. So this pushes everything over to the FBI and James Comey, working, of course, under the supervision of the Deputy Attorney General, Rod Rosenstein. And that was going along, I guess, reasonably well, except for yet another conflict problem, that lawyers in the government have a responsibility to their client. The client is the United States government. And yes, we take instructions from political superiors, but when the political superior goes so far as to say, well, you really need to be loyal to me, not to the government, or if there's a conflict, really what's most important is being loyal to me, there is a serious problem. Once again, you could describe it under the ethics rules for lawyers, that very broad rule, Rule 1.7. But regardless, James Comey is director of the FBI. Granted, he wasn't acting formally as a lawyer in that context. He felt he ought to continue with the investigation as he wished, as he believed appropriate, and we all know what happened there. Then that is where we get Robert Mueller, appointed by the Deputy Attorney General. A whole host of new issues come up, because Robert Mueller is coming in from a private law firm. So issue number one that has to be dealt with is client conflicts with respect to the former law firm, former clients. Now, fortunately, Robert Mueller had not represented anybody at all himself in connection with the Russia investigation, but several of his partners in his law firm, WilmerHale, were, including Reginald Brown, who's my former colleague from the Bush White House, who I believe was representing Jared Kushner and maybe one of the others, Paul Manafort. So what do we do about that? Well, actually, under the ethics rules for lawyers, it works. You leave the law firm, and you have conflicts with respect to your own clients that you represented, but you can, if it's appropriate, it depends on the circumstances, you can go adverse to clients of the law firm you were with previously if you did not represent those clients and you do not have any other allegiances, such as financial interest in a law firm or anything else that might make it difficult for you to do so. So the ethics rules for lawyers worked for Robert Mueller. The rule he did need to get we call it an authorization under, was a government ethics rule. The government ethics rule says that you should not represent the government in a particular party matter if your former employer, including a law firm that you're a partner of within the past year, is a party or represents a party, unless you get an authorization from the agency ethics official. So what we have here is, once again, in addition to the ethics rules for lawyers, which gave a pretty clear green light to Robert Mueller, you have this additional layer of regulation, which applies to all United States government employees, and that didn't prohibit him from taking this role, but it required the authorization, which I looked at. There was, of course, a great deal of fuss about it at the time, but really, quite clearly, it was appropriate to give the authorization. There's the fear, of course, when you think, why do we have that rule? Is he going to bend over backwards to favor the clients of WilmerHale, Paul Manafort? Well, I don't think he has bent over backwards to favor Paul Manafort. I think that authorization has worked out. And that's another thing you learn in professional responsibility class, is that conflicts can, in appropriate circumstances, be consented to. And this one was. So there we have Mr. Mueller firmly in place, and I believe without himself having significant conflicts of interest that have not been dealt with through appropriate authorization. But what about his staff? Now he's going to have to bring in additional lawyers. What should the rule be? That we should bring in lawyers who have never, ever given any money to either campaign? I mean, you could have that rule, and he was criticized for bringing in some lawyers who actually donated to Hillary Clinton. There are, yes, some lawyers who support Democrats. Some lawyers who supported Donald Trump. You could say, well, you wouldn't bring in a lawyer who supported either candidate or gave to either candidate, but you're going to cut down dramatically on the availability of staff for this investigation if you draw the line that strictly. There certainly is criticism of that, but then I think about what's going on in United States attorneys' offices all over the country with United States attorneys who were partisan supporters of the president. We always do. Most United States attorneys come from the president's political party. Many actually participated in one way or another in the campaign or gave money. And Americans can be prosecuted by these United States attorneys all over the country. And so somehow it would be somewhat strange to say, well, the president of the United States is being subjected to great persecution or something because there might be some lawyers who actually donated some money to Hillary Clinton during the campaign on Mr. Mueller's staff. But that argument was made. And once again, I think you get back to a broad standard of, did Mr. Mueller hire a staff of lawyers who can put aside their partisanship, if they had partisanship in terms of who they preferred to win the election, and do the job of a lawyer, which is to represent your client here, the United States government, in conducting a fair and impartial investigation and then prosecuting where there's evidence of crimes. Thus far, the evidence I've seen convinces me that the staff that Mr. Mueller has hired has done that job and done it reasonably well. But what you can see here is lots of conflict issues arising and being discussed, as they should be discussed in the context of the Mueller investigation. The concerns about conflicts should not be brushed aside. But you also cannot avoid conflicts entirely, because think about the alternative. What if this investigation were being conducted by a political appointee? Indeed, probably you could have had this investigation conducted by a political appointee who did not work for the Trump campaign. Might be someone who supported Donald Trump, but did not work for the campaign. Probably recusal would not be required under Rule 1.7 of the Attorney General if he had not worked with the campaign. But how would it look? Doesn't it look much better to have an independent prosecutor? The message I want to convey here is that conflicts are very difficult to work with. You're always going to have some conflicts, some conflicting loyalties in the practice of law. It's very, very difficult to avoid some conflicting loyalties. There are things pulling you in different directions. But we expect lawyers in the vast majority of situations to be able to loyally, competently, zealously serve their client. And in this capacity, it is the role of the lawyer as an investigator. Now, I want to I'll turn to the role of lawyers inside the White House. I did that job for 2.5 years under President Bush, and some interesting topics, including up-the-ladder reporting of illegal activity and other things. But I want to turn this over to David so we can focus on the investigations and some of the other issues that he wants to talk about.
Well, I guess I'd like to say a few words about how to think about lawyers' ethics in a time of hyper-partisanship, because I think that the idea of professionalism and the idea of ethical rules for lawyers it isn't and it shouldn't be a partisan idea. It's an anti-partisan idea. So part of legal ethics is a whole bunch of rules. That's what's on the MBE. There are rules about recusal, as Richard pointed out, and it's important that people follow them. But part of what we talk about when we talk about lawyers' ethics and legal professionalism is an ideal. It's an ideal of impartiality and of nonpartisanship, and of avoiding the appearance of partiality or partisanship. And I was a prosecutor for 7 years. I worked under 2 Republican administrations and a Democratic administration. I worked on cases that had political implications. I was involved in a major case growing out of the savings and loan scandal of the 1980s, and that was a scandal that involved political contributions to major national political figures. It touched on the families of one of the presidents that I served under, and I have to say, in the 4 or 5 years that I was working on that matter, there was not a single occasion in which anybody suggested to me that our work should be dictated by or pay attention to political considerations. So that when I was working on this case during the transition from the first Bush administration to the first Clinton administration, and there was no change in the way the investigation was conducted when that turnover happened, and that's as it should be. I think that if you understand professionalism in this way, it plays a really important part in democracy. The rules of legal ethics sometimes can be seen as things that obstruct the will of the majority, and I think that's the wrong way to think about it. But you can have different ideas about what democracy is about. If you think that democracy is like a conveyor belt, you start out with the will of the people, and you just translate that into policy, then you're not going to have much need for or room for legal ethics. But if you think about democracy the way I think about it, as a system for people of different backgrounds and different views to live together and govern themselves peacefully, then you need an ideal of nonpartisan, impartial lawyering. So I think it's super important that legal ethics and the ideal of professionalism be a real ideal and not get turned into a bludgeon to use against political opponents when it seems convenient. And I think that the tools of lawyers are actually pretty important in making sure that happens. That's why when we talk about legal ethics, we try to have rules that are settled in advance. And it's why when we have ambiguities, we try to reason by analogy. We look at precedents. We come up with hypotheticals. We try to imagine how we would feel about things if the partisan positions were reversed. We do all those things in an effort to make sure that as much as we can, legal professionalism is what it should be, which is an ideal of impartiality and not simply partisanship by other means.
Great. Thank you. I want to start by saying a word about lawyers serving in an administration whose policies they often disagree with. And I was asked to write something on this by the American Constitutional Society, and also I've had conversations with students in the last year or so about their own professional futures in government service. And what I essentially said, which is it depends, is the most irritating answer that an ethics professor can ever give to a difficult ethical question. But I think it's the only one that makes sense in this context, and it's my response to whether ethically responsible lawyers can or should serve in an administration where they disagree with many of its objectives. And I think the key factors have to be what the position is and how much ability the lawyer has to accomplish ethically defensible ends. And I begin from the premise that it will not serve the public interest if the only lawyers in government positions are those who share the president's views on particular contested issues. There are a lot of relatively apolitical jobs in the federal government in which lawyers can do really good work in both a descriptive and prescriptive sense. And to take an obvious example, the Enforcement Division of the EPA urgently needs attorneys who have environmental commitments that their president may not share. But I think the only way for an ethically responsible lawyer to serve is if they're prepared to resign when resistance is ineffective and the moral stakes are substantial. And it's never enough, I think, to rationalize complicity on the ground that their actions are ensuring a, quote, lesser evil and that their successors would do worse. As Hannah Arendt warned a half-century ago in talking about the Holocaust, the weakness of that argument has always been that those who choose the lesser evil forget very quickly that they chose evil. And contemporary psychological research reinforces that concern. Psychologists know that when people feel pressure to act in ways that are inconsistent with their values, an uncomfortable state of cognitive dissonance results, because individuals care both about being and appearing ethical, and when that clashes with a desire for recognition or power or influence, then people often attempt to rationalize the dissonance by rationalizing the unethical conduct. And as one philosopher put it, The rationalization of working from within has kept many queasy people tied to many appalling ventures for remarkably long periods. And that risk, I think, is compounded when repeated exposure to the problematic conduct produces what psychologists describe as ethical numbing. It's a kind of incremental process in which small, morally troubling acts pave the way for larger ones. And it leads to an escalation of commitments that's sometimes labeled the boiled frog problem. Legend has it that the frog is going to jump out of boiling water, but if it's placed in tepid water and the temperature is just gradually increased, the frog will calmly boil to death. This turns out to be wrong about frogs, but right about people. A cottage industry of organizational research finds that people respond to cues from their peers and leaders, often replicate their behavior, and become numb to some of the consequences. So the bottom line is, I think lawyers who find themselves in those political environments need to be pretty vigilant about maintaining their moral compass. They have to draw some lines in the sand and be willing to accept personal responsibilities for the consequences of their actions. And they should ask whether those consequences are fundamentally consistent with constitutional principles, with legal mandates, and personal values. We've had already some notable examples of lawyers in this administration who've exercised that responsibility. Some 700 EPA individuals have resigned. Donald McCann, the White House counsel, reportedly refused to fire Mueller and kept his job when he called Trump's bluff on that. Sally Yates, the assistant acting attorney general, refused to defend the travel ban and knew she would lose her job as a consequence. And I think those are actions that give us hope that the ideals David mentioned will be still very much alive even in this troubling era. And now just a moment about the lawyers for Donald Trump and particularly the Michael Cohen, Stormy Daniels affair. For anyone who's been on a different planet during the last few months, I'll just recap slightly. Michael Cohen, a self-professed fixer for Donald Trump, arranged a $130 payment to a prominent porn film star known as Stormy Daniels to keep her silent about an alleged affair with Trump shortly after the birth of his son, Barron. The payment occurred in the closing days of the 2016 presidential election, and a number of government groups have filed complaints with the Federal Office of Communications and the Department of Justice, claiming that the money was an in-kind contribution to the presidential campaign. President Trump has denied the affair and sort of denied any knowledge of the payment or where the money came from. Daniel's lawyer then sued to void the non-disclosure agreement because Trump apparently never signed it. Meanwhile, Robert Mueller referred some evidence about Cohen's illegal activities to the U.S. attorney in New York, who petitioned the judge for a warrant to search Cohen's offices and residence. This caused the Trump administration to express outrage over the violation of the sanctity of the lawyer-client privilege. Rudy Giuliani, who's now joined the president's team of lawyers, equated the agents with Nazi stormtroopers, a description which Cohen himself inconveniently denied. He said they were perfectly polite. A New York judge then appointed a special master to review the material and decide what material was legitimately protected by the attorney-client privilege and what material might reveal evidence of Cohen's assistance in crime or fraud, which would not fall under the attorney-client privilege. Cohen himself has said he will plead the fifth and take a, quote, bullet for the president, and that's kind of now being tested. Trump initially claimed that he didn't know why Cohen made the payment or where he got the money, and that lasted for a while until the explanation evolved when Rudy Giuliani last week said that Trump did know at least about the general arrangement by which Cohn would, quote, take care of things like that, just like, as Giuliani put it, I take care of things like that for my clients. I don't ask about every little single thing that comes along. These are busy people. Well, okay, leaving aside whether Trump has too busy a schedule, to just answer a simple question like, Mr. President, do you want to pay off a porn star for silence about sex you say you didn't have, which presumably would not interfere unduly with his golf games and television watching time. However, Giuliani was forced to walk that back after Trump announced to reporters that he was just one day on the job. That turns out to be not true, but he needs some time to get his facts straight. That does turn out to be true, although perhaps he might have done that before going on national television. And of course, everyone had a field day pointing out that this was just like the most incompetent lawyering that they've ever said. It was reported that Rudy Giuliani's conduct here might have been anticipated when he was a prosecutor in New York. It was said that the most dangerous place to be in New York was between a microphone and Rudy Giuliani. So in any event, he seemed to enjoy going on the talk shows. And, as one late night television critic said, you got to write these lies down, because you get to a certain age and, you kind of walk into the room and you forget which lie you walked into it with. And, the inconsistency of the explanations, leaving aside, any questions about which are credible and which aren't, raises some obvious questions about, once again, the credibility of the statements that are coming from the White House. So lots to talk about there. And we could also say a word, if people are interested, about the issue that has cropped up for the Solicitor General's office with respect to a reproductive rights case that arose in Texas. Some of you may have heard about this. Essentially, the administration was seeking to oppose a pregnant teenager's desire for an abortion while she was being held at a detention center. And the facts are sort of complicated, but because of Texas's extensive procedural rules requiring counseling by the same doctor who does the procedure and a 24-hour waiting period in between, and her inability to get any doctor who had provided the counseling to do the abortion properly. There was some back and forthing about the scheduling, and it turned out that her lawyers learned that the first doctor who had provided the counseling suddenly became available to do the procedure. They didn't inform the government's lawyer about that, although they did inform the shelter. And the government claimed that that violated the lawyer's obligations to be truthful, even though those model rules about the truthfulness always have a caveat except for matters that are protected by the attorney-client privilege. And it's pretty clear that her decision to have an abortion and the timing of that procedure was a confidential matter, and that if it had been disclosed to the adversaries, they would have sought a stay and tried to run out the time on her ability to obtain an abortion under Texas law, which has a 20-week cap, and she was already 16 months pregnant. The issue is coming up in some other cases in which the administration has sought to prevent abortions by detainees, especially minors. But it's particularly notable in this case because the SG asked the Supreme Court to grant cert and to vacate the ruling of the en banc panel of the D.C. Circuit, which had ruled she had a right to an abortion on the ground that the lawyers had committed a disciplinary violation. So that case is still pending, and there's much hand-wringing among ethics experts about whether anything is going to come out of the Supreme Court that would cast aspersions on her lawyers for doing something that seems to be clearly within the ethical rules. So I'll stop there, throw it open for questions, and because we're taping these without a roving mic, please ask your question loudly and we'll recap it slightly for the audience in the video recording. So, anyone? Yes?
Do you think the goings on with lawyers in Washington right now is a permanent moving of the fence or raising of the bar, or is it just a perturbation that'll disappear with the next administration?
Is there a permanent change in the ethics standards? I don't think so with lawyers. I think most lawyers, there are some exceptions for sure, and we've talked about some of them right here. But I think most lawyers are sticking pretty closely to what they ought to be doing. I mean, I disagree with Attorney General Sessions on a lot of things. His testimony in answer to Senator Brackett's question was incomplete at best. But his decision to recuse in the conflicts rules was right. And I think Rod Rosenstein, we've had a number of lawyers in the Justice Department who've done the right thing. And others realized they didn't, like Rachel Brand, who was number 3, and she would have been the person asked to fire Robert Mueller if the first 2 had been fired, and she decided to get out of there and took a job as general counsel at Walmart. Now, I might take any job at Walmart over having to work in the Justice Department right now, but I think those who are willing to do it are for the most part, I think, living up to the standards, for the most part. In the White House, it's a little shakier what's going on over there.
You know, I think it's a fair question. Are we at a new normal? And I think some of it depends on what the next administration is. Is it 4 more years of same, or is it, a change of administration with people with a deeper commitment to ethical values? But I think if you look over the course of history, you have some reason to be optimistic. And certainly the administration that preceded this one had a pretty high bar for ethical conflict, and we were relatively free of these kinds of scandals for quite a long period. Yes?
I'd love to go a slight tangent and ask, as you look at the judicial level and the people that are being put in place there, which to me does have that longer-term impact, do you have any, we all can vote clearly for that next administration, but do you have any concerns, and are there many things that normal people can do about it?
Well, I personally have huge concerns. I mean, I think that's one of the most enduring legacies of any administration are the judicial appointments, and they're going to last, far beyond the term of this president. And I'm concerned not just because of the politics surrounding who can get nominated and confirmed at this historical moment, but also the sort of manifest lack of qualifications of some of the candidates which have been exposed during the confirmation process. A few have been forced to withdraw, but some it's just breathtaking. And the administration seems utterly unconcerned with their rankings by nonpartisan groups. And so there does seem to be a litmus test on certain issues. And all of that, I think, should propel voters to the polls if that's not the kind of criteria you want for judicial selection.
I think I'd agree with that. A lot of them aren't that much different than what we had of George W. Bush. I think that there are more quality problems in terms of qualifications. The ideology, I think, is roughly this. They may be further to the right, but it's not a huge difference. Because there was an agenda to push through a lot of very, very conservative judges during President George W. Bush's administration, and I watched that. So that's an area where it's changed somewhat than what you would have expected if you had had another Republican administration under the same influences that this one has. The vetting is sloppy. I think sloppier than under President George W. Bush. But the judicial nominations are probably not as sloppy, the vetting, as some of the cabinet positions. On the whole, I'd say the quality of the judges on the whole, in terms of experience, I don't think is that different than George W. Bush's administration. If you're going to compare two Republican administrations, I'd say the vetting is not as good. There are more who are unqualified, but I don't think it's a huge difference. I think in terms of their ideology, though, this idea you got to put very conservative judges on the courts has been going on for a long time, and I don't think we can just attribute that to Trump. I guess that's my point.
I think there has been a change, though, with regard to that last point about how we talk about judges. And just as I think it's important that we hold on to the ideal of impartial, nonpartisan legal professionalism, I think it's important that we hold on to the ideal of nonpartisan judging. And it is becoming more and more common to refer to judges by their political affiliation and to assume that we know how a judge will rule based on her political party. And that can be a self-fulfilling prophecy. And I think it's bad and dangerous. And it is true, as Richard said, that there's a long history of appointing judges based in part on their ideology. But I don't think there's a long tradition of openly celebrating the practice of appointing judges based on their partisan affiliation or ideology. And I think that's a dangerous practice that should be avoided.
Well, and also the commenting, you will recall the, quote, so-called judge statement by Trump in referring to the ruling of a judge who was a U.S. citizen but happened to be of Mexican ancestry, on the assumption that he couldn't rule impartially on the case against Trump University. And I think that kind of trashing of the judiciary just is a huge problem. And I do think, I agree with Richard's general comment about, the ideology has preceded this administration. But it did strike me as a kind of low moment when I watched the testimony of who is the judicial nominee who had never argued a case before a court, never ruled on anything, never, it was just like, well, anyway, that was just embarrassing for the country. Bob?
I was wondering if you could clarify the difference between the ethical roles of the White House counsel and the president's personal counsel. What can be said about the distinct ethical roles of these actors?
The question is, who is your client? The White House counsel, your client is ultimately the United States government, and the president only in his official capacity, to the extent the president is carrying forward his or her duties as set forth in the Constitution and the laws of the United States. But your client is the United States government. So, for example, there may very well not be, as President Clinton discovered, an attorney-client privilege. You cannot keep those communications secret from Bob Mueller or anybody else, because the government has the right to know about the communications between a government attorney and another government official, no matter how high up that person is. So your ultimate client, your zealous advocate for your client, but your client is the United States of America, the executive branch, the president in its official capacity. The personal lawyer is in charge of the personal stuff. If President Clinton had some personal issues, President Trump has a lot more personal issues. And the personal lawyer, his loyalty is to the president himself as a person, Donald J. Trump, whether he's president or not. If Donald J. Trump were to resign tomorrow, that lawyer would still represent him in his personal capacity. Of course, the White House lawyer no longer would. So it's two very different sets of loyalty. But I got to say, if something illegal is going on, You're a lawyer for the government, you have up-the-ladder reporting obligations. And even if the President of the United States, he may be at the top of that ladder, but if he's violating the law, you're going to have to report that to the Justice Department. You've got to report it. If you are a government lawyer and you know criminal activity, you're going to have to inform the Justice Department, the Public Integrity Division. Your loyalty is not to President Trump no matter what he wants. You don't take a loyalty oath to him as a person if you're the White House lawyer.
Do you think that often happens, Richard, that there's that kind of reporting within the White House counsel's office?
We had one or two cases that I thought where if there's a violation of a statute or evidence of a violation of a statute, I insisted the Justice Department Public Integrity Division be told. You just have to. So, by a White House staff member. It's something that didn't end up being prosecuted, but it was enough evidence to feel they ought to know, and they could take a look at it. These are career lawyers over at the Public Integrity Division. So it's important. I still remember, though, I was being interviewed for the job in 2005, and I had just pushed through Congress in 2002 this idea that lawyers for corporations ought to have to report up the ladder, and I've been making a lot of noise about that back in 2002. And I still remember when they interviewed me, they said, up the ladder reporting. So does that mean you're going to be running into the Oval Office every time there's a problem? No. But it's important. I mean, whether you're a government lawyer or a corporate lawyer, communication stuff, you don't just shovel stuff under the rug. You have a client, and it's the government of the United States.
Yes.
So, to stay on the topic of the president's personal lawyers, there's been a lot of talk in the media about his inability to secure private counsel. Ted Olson said no, a bunch of other big names have said no. And I'm curious if you could speak to the desire from an ethical lawyering perspective to balance representation of a client in the criminal justice system with representing a client who seems pretty hell-bent on either not cooperating with his own counsel or not cooperating with opposing counsel.
Well, the system only works if people have representation. And there are people sometimes who find it difficult to get lawyers, and it's important that they have lawyers. So that's why it was good for John Adams to agree to represent the soldiers who were accused of carrying out the Boston Massacre. But I don't think that Donald Trump is a person who's having difficulty getting a lawyer. He has a lot of lawyers, and I don't believe that he's always chosen wisely in the lawyers he picks or the instructions that he gives to those lawyers. But he's hired Williams and Connolly now, so he has lawyers. So I don't believe that this is a situation where a defense attorney who is asked to represent Donald Trump needs to feel bad about saying no. And this is a situation where an attorney can decide whether this is a client that she feels comfortable representing. If we ever get to a point where Donald Trump can't find anybody to represent him in a criminal case, then I think the ideals of the profession will have different implications for lawyers who are asked to step in.
I have two law school classmates who turned down that possibility. Robert Giffro is one of the lead lawyers at Sullivan and Cromwell for Volkswagen, and he was approached, and for whatever reason that was turned down. The other was George T. Conway, senior partner of Wachtell Lipton, Rosen Katz. He has, by the way, a wonderful Twitter feed. His wife doesn't appreciate it. But they can sort that out in their marital relations. But anyway, George Conway is approached for a job in the government. I think they've been approached for the private lawyer job as well. The problem with Donald Trump is, one, you usually don't want to have a client who's tweeting all the time about the case. Generally, that's not advised. Second, you don't want a client who's not telling the truth. If you got a client who's not telling the truth, it's going to expose the lawyer, because you're going to all sorts of client perjury dilemmas and all that, the Nixby Whiteside case, and you really don't want to be there, and so that's a problem. And then you've got the client perjury problem, or clients who aren't telling the truth, and then they don't have their story straight, and that's even worse. So he's not an easy client to manage. He's hired very tough lawyers. He hired his first lawyer he hired was Roy Cohn, who worked for the McCarthy hearings. So he likes the idea the lawyer's a tough guy, but not every lawyer he thinks that basically they're either a bouncer or a payoff guy. That he's a difficult client to work for. I'll just put it that way.
Yeah, Michael.
So I think it's inevitable that Trump will fire Mueller. And I wanted you to game through with me, how is that going to go? Who would do it? There is a regulation that protects him from discharging up to cause. Get by that. Who's the new special counsel? What happens to the investigation?
I hope not. It's a mess. There's a great article in the Concord, New Hampshire Monitor about Robert Mueller and Archie Cox, who actually went to the same high school in New Hampshire. I was hoping that would be the only similarity they'd have, because I've got to say, I'm not so sure he will. I think if he was going to fire Mueller, he would have pulled the trigger earlier on, because the further this investigation goes down the road, the more Mueller's gathering. And I think there is going to be a very, very strong reaction, just as there was with President Nixon when he fired Archie Cox, which would mean that somebody else would step into the shoes of Robert Mueller. Robert Mueller, I think, is a great lawyer and a great prosecutor, but he's not the only one in town. And I don't think the Republicans on the Hill would let him get away with that. Now, of course, I'm guessing. But he tests their patience too much, and they start thinking about going into election. They start thinking that Mike Pence starts to look pretty good to them. The Republicans, the Democrats may have a different view of that. And if Mitch McConnell were to stand up enough, then it's over. And I don't think the members of the House or Senate would appreciate a Mueller firing. There's going to be a firestorm over it. And, as I say, another prosecutor, just like Leon Jaworski replaced Archie Cox.
Well, who would appoint the new prosecutor? How would all that go?
It would be the Attorney General or the Deputy Attorney General, but there'd be enormous pressure, as there was in the Nixon situation, to appoint someone of integrity, someone who was going to actually do the job. And that's what happened with Leon Jaworski. He was appointed by the Justice Department as the prosecutor, and he actually turned out to be, if anything, even stronger as a prosecutor than Archibald Cox had been, because Jaworski had a lot of trial experience. I just don't see an upside for President Trump from firing Robert Mueller. I think it could cost him his job. And certainly, I know what I would do if I were Mitch McConnell. I'd let him know privately if they haven't already. I don't know, that if he fires Mueller, they're going to pull the plug on him, which they could do. The Republicans could pull the plug on him.
From your lips to God's ears. Yes.
It seems to me that since you're out of law school and there's students in that we can't escape the fact that students at this law school have a decision making in the firms that they're going to work at, some of which are going to represent the president much more than they listed in their staff papers. What roles do you see students having in that obligation to choose where to work with comment on
Well, this dilemma isn't completely new. There have always been big, important clients that some law firms take on that lots of students have had problems with, cigarette companies, so it's a long-standing quandary that students have to address, of figuring out where they want to work and how much it matters to them what business the firm does and what understandings they want to go into with the firm. So some students may decide that they're happy, they don't mind working for a firm that represents Donald Trump, and they don't mind representing Donald Trump as long as they act ethically, as long as they themselves act ethically. Other students may decide that they are happy working for a firm that represents Donald Trump, but they don't want to personally do that work, and they want to make sure that the firm's okay with that. Some students may feel they just don't want to be at a firm that represents Donald Trump. So I have friends that made the equivalent decisions of in all three versions with regards to firms that represented asbestos companies, firms that represented cigarette companies. And I think that a person of conscience, of good conscience, can make any of those decisions. I don't think any of them are ethically required. It depends in part on how you are comfortable, what you're comfortable with, and what feels right to you. I do think that regardless of where you go to work, it's important to prepare yourself for ethical challenges. And this is something that Deborah was talking about earlier. Even if you go to a firm that doesn't represent Donald Trump and has turned him down, you're going to face in your career at that firm some moments when you are in a position where you're asked to do something that you don't feel comfortable with or that you shouldn't feel comfortable with. And I think it's important for people going in at the outset of their careers to not just to understand what the ethical rules are, but to have strategies for what they're going to do to make sure that they can wind up following the ethics and holding to the ideals that they want to do. And it's not enough just to say, well, I'm just going to resolve that this is really important to me. I think you need practical tools like figuring out in advance where your lines in the sand are, or reaching an understanding with your employer before you go in about things that you're not comfortable dealing with. I think a critical tool for any lawyer in any organization is to find other people in the organization who you feel comfortable talking to and working through ethical challenges that arise. I think that that's just critical, and it's very hard for anybody to navigate any the ethical challenges that arise in any career for any organization without having some people that they can talk through things with.
My advice would be to look at the broad picture, not just a few sort of hot button issues. And I remember when I was in law school, as well as the law firm represents South Africa, or there'd be a handful of issues, sort of hot button, and that became the big moral, on-off. And people ignored the bigger picture, which is, what is the law firm doing, spending a lot of its time doing, and what are you likely to be asked to do? If you're going to go become a corporate lawyer in certain law firms, you will be working on certain types of transactions. And a lot of those transactions did lead to the financial crisis of 2008, the way corporate law, I think, was practiced in a number of places. Tobacco. There are some law firms that when I was in law school were doing a lot of those tobacco cases, and others that were not. But a law firm that had all those tobacco cases needed to put a lot of associates on them, and it might be very difficult not to do tobacco cases. And at that point in time, it might very well be something else now, particularly in the financial area. But you ought to be looking at, what does the firm do, and are you going to be pressured to get into stuff? You yourself, it's really a question of what you're going to be doing at that firm. That years later, you're going to say, well, I spent 5 years of my life working on mortgage-backed securities transactions. What 5 years? Oh, 2003 to 2008. That may or may not be a resume you want. So you try to, of course, you can't predict the next 2008. But I look at what the big picture, what the firm is doing, and where are you going to fit in? Because I think you can say, I don't want to work on the Donald Trump case. Because they don't want to put you on the Donald Trump case if you don't like Donald Trump, and he doesn't want you on that case. But the larger volume work may be hard to avoid. You got to think through the big picture of what the law firm's doing.
Yes.
A substantial fraction of the members of the House and Senate are lawyers by training. Richard talks about the Rule 1.7, and I'm just wondering, to what extent do these ethics issues apply only in the practice of law or in your larger role in society, because these people are making policies? And so
would being a lawyer tell them they ought to be doing in the policymaking process?
That's because I think that one rule would apply 1.7, I believe, only when you're actually representing a client technically. But a lot of the rules about integrity, honesty, some of the broader rules, and I think apply no matter what you're doing in the government. And for example, I think, Deborah, you might have some things to say about Kellyanne Conway is a lawyer. She is a member of the District of Columbia Bar. She's not now functioning as a lawyer, you could tell. And yet there are some issues about whether the DC Bar's rules are complied with.
Yeah. Well, you know, the bottom line is lawyers are accountable for what they do 24 hours a day and can be disciplined for conduct outside of their work as lawyers. So whether that's in politics or their personal life, you know, any felony, any dishonesty, the rules are pretty clear about that. In my ethics class, we talked about a complaint that was filed by a number of ethics professors against Kellyanne Conway for essentially factual misrepresentations. And, you know, I didn't sign, I was asked to sign on to that, and I didn't, partly because, you know, historically, disciplinary agencies don't get involved in politics if they can avoid it. I mean, they don't have enough staff to go after the people who steal their clients' money. So, you know, setting them out on a, you know, crusade to clean up the representations made by every lawyer who works in a political capacity would be like, you know, the Aegean stables, I guess. You know, so, you know, one thing that lawyers do in political context is spin and trying to figure out what's an intentional falsehood and, you know, what's just putting the best possible cast on something is extremely difficult, time-consuming, would not have much credibility, I think, with the public in this atmosphere and would not be a good use of Bar Disciplinary Committee resources. That having been said, I think it's perfectly appropriate to criticize Conway for statements that she has every reason to believe are not accurate, and certainly for things that seem to be a clear violation of government ethics rules, like plugging Ivanka's whatever. What was her line of business and, you know, whatever department store, you know. Anyway, you know, from the White House lawn, you just don't do that, and so, you know, she got slapped around a bit in the press, I think, appropriately for failing to separate out her personal loyalties to the president and, you know, what she was doing in her official capacity for the White House. Yes?
So one thing that Giuliani said was that Trump had repaid Cohen in the form of a retainer. My understanding of a retainer is that's payment for the right to use that lawyer's services. So is that just a difference in terminology, or is there a bigger issue?
Well, what seems to have happened, although, as I say, the explanations evolve constantly, is that he was getting a $35,000 retainer to handle, quote, stuff, and that he had broad discretion over that, and then he would get additional money to handle expenses of, you know, so some $400,000 in toto was under his auspices, according to the New York Times' latest version of what went on. And Giuliani said, well, you know, this is perfectly normal for, you know, people to do this. And Jeffrey Toobin, who's a lawyer and a legal commentator, who was on one of the Sunday morning talk shows and was shown the clip in which Giuliani explained how lawyers do this all the time. He says, well, you know, who does that? The mafia, maybe, but, you know, people do not create slush funds for their lawyers to pay off people for silence with no sort of sign-off from clients. That's, you know, not normal legal practice, you know. And so I think regardless of what the arrangement was, you gotta have some questions about its ethics in this particular context.
So would that be the New York State Bar?
Well, yes, there are claims that he could be subject to any number of ethical violations. There at one point before it was suggested that he was reimbursed by these funds and that he had just done it out of his own personal mortgage money, out of the kindness of his heart. Well, that turns out to be an ethics violation because you can't advance money or in-kind contributions to a client who's not indigent. And there were also questions about the campaign finance laws because you've got to disclose payments that are being made on behalf of the candidate. And Rudy Giuliani, unfortunately, complicated the picture for Trump's team, claiming that this wasn't a campaign expenditure. This was just designed to protect the president's family from knowledge of this unseemly conduct by saying in another morning talk show, oh, what if this had come out 2 weeks before the election? So, that's your lawyer there. And, that's sort of the problem of competency and consistency in that I noted earlier. Other questions? We have time for a couple more. Yes.
Hi. So I know the event was billed as nonpartisan, and the topic has come up frequently here. There's an importance in our professionalism to be anti-partisan or nonpartisan, but the tone of the event has kind of suggested otherwise. So I'm curious what your advice is for the few students who might be right of center who would consider government positions, short of changing political parties or resigning from their job. How does one be ethical in government service? Because so far the model that we've had are switching parties or being willing to resign.
Well, I just want to be clear in what I said before, if it didn't come through. I think there are lots of ways to be an ethical lawyer in the Trump administration, and we need ethical lawyers in the Trump administration. And a lot of what lawyers do for the federal government is not particularly political. And, God bless all those lawyers in the Justice Department who are, living up to the ideals that David described. So, if I created I thought I was kind of clear on that. The point I was making is not that lawyers shouldn't go there or couldn't ethically go there. It was that when they go there, they need to know where their lines are, and those are going to be different for people with different political views. And if you're comfortable with a lot of Trump's policies, I think you're much less at risk in this administration. But I think for any lawyer, there are going to be circumstances like some of what we've described today that regardless of your partisan views and your political views, you might feel like you're being pressured to cross some ethical lines. And that's what I'm trying to suggest lawyers should think about, where they want to draw those lines before they get into a position in which they're under enormous pressure to just go along.
I'd say two things, Camille. So first, I think there are lots and lots of lawyers who are serving in the Trump administration and are doing really good work and are helping the country. And I think there are lots of lawyers of all kinds of ideological commitments who are serving in government positions outside the federal government. So I would say to a right-of-center student who is interested in government service, I would say the same thing I would say to a left-of-center student who's interested in government service. I think it's a good thing. So I've worked for 7 years as a government lawyer and loved it, and I think it's a good and honorable, exciting thing to do. I did want to say something about partisanship. So I do think that it is tricky to figure out how to be nonpartisan in talking about legal ethics in the current moment. And the reason I say that is because I think that the president is pretty firmly against the whole idea of legal ethics and ethics in general. And I understand not everybody may share that view, but that is my read of his commitments. So I think that, I don't believe that being nonpartisan and thinking about legal ethics can mean you need to make sure that what you say is something that somebody, that the president would agree with, or that somebody who supports the president would agree with. I do think, though, that there's a trap for anybody of any political persuasion in thinking about legal ethics. It's very easy to start letting legal ethics just turn into a bludgeon to use against your opponents, so that's why I think it's super important, as I said at the outset, to try to test your instincts by looking at rules, looking at precedents, by imagining how you would feel about things if the shoe were on the other foot. In the Solicitor General's brief, in the case that Deborah talked about at the outset, one thing that Solicitor General did that I thought was good was try to argue by changing the hypothetical and say, how would you feel if the positions were reversed and this was a death penalty case? And I'm not sure that they came up with the right analogy, but I think that general tactic was a really good one. It's what I think the Solicitor General's office should be doing internally as well as externally in trying to figure out if they're taking a principled approach. And so I do think it's possible to do that in this administration. I think that there are challenges because I do think that I think that the person at the top of the administration is hostile to the ideal of professionalism, at least as I understand it. But that doesn't mean that you shouldn't work for the government, or that people of good conscience can't work for the government. It's important that people of good conscience are in the government now, and we'd be way worse off if they weren't.
Last question, Joan.
You talked about having to report up. A government lawyer always has to report up to the statutes being violated. But there is no personal loyalty of the person. But what if the requirement of a person or of a political faction is that in order to work in that office, you have to take a personal loyalty oath? Would that be
personal loyalty oath?
No, you are working for the government, but for a subset of people, one person or a subset of people who require, in order to work in the office, you have to take a personal loyalty.
Loyalty to a person. Loyalty to a person.
Yes.
I think it would be a conflict unless it were qualified by loyalty to that person's decisions, policy decisions, into carrying out that person's policy decisions, because that's how they're put. But if that person is outside the scope of acting outside the scope of the United States Constitution or the statutes of the United States, in your view, whether you're right or wrong, you as a lawyer, if you have a client who is insisting on acting illegally, your client is the United States, and you cannot have an oath to a person that takes priority over your duty to the United States of America. And that's where you may find someone else who might disagree and say, well, what the person is doing is legal. Then fine, they take the job and you move out. But I don't think you can have a loyalty to a person.
So the personal loyalty would be if the person says something and violates the statute
or the Constitution. Well, no, you're loyal to the United States. But the thing is, the people of the United States do choose the elected representatives. We have a procedure for choosing the president. We have a president. So if the president decides this is the policy I want to withdraw from the Iran agreement or something like that. If he is going to withdraw from the Iran agreement in a way that complies with the Constitution and the laws of the United States, and you're a State Department lawyer, and you believe that's morally repugnant to you, then you could resign. You can always resign if your client is doing something you find morally repugnant. You can leave. But I think you do need to, if you're in the State Department and you don't want to resign, and the president has figured out a way to, consistent with the Constitution and the statutes, to withdraw from the Iran agreement, even if you want to give lots of other advice, you stay or you leave. Now, there are going to be other situations, such as the torture memos in the Bush administration, where it was illegal, and they come up with a memo to try and justify it, but the memo is just packed full of holes. And so there, what is happening is the lawyer is being convinced to try and characterize that which is illegal as legal because the political superior wants it. And there, that is, I think, what is wrong, where the loyalty to the powers that be, and I use that example because it's not just about Trump. We've had in other administrations. The loyalty, the political loyalty is taking precedence over the loyalty to the United States.
I think we have to leave it there. Thank you so much, Richard. Thank you.